intent is clear and proven, would still and can still constitute. The wording that we will be using notwithstanding. The point I'm driving at, Mr. Chair, Manong Roy, is kailangan pa ba nating hintayin na 150, 20, 1,000 ang patayan?
I think he says killing one should be retained.
No, he's saying killing one should not.
Is that what you're saying?
Yes. Kasi, hindi ba, kailangan ba natin...
I thought you meant, I'm sorry, I thought you meant killing one should be retained. And I agree with my chairman that killing one...
It's a question of intent.
Yeah.
If we can prove intent, that the intent is to commit genocide, I don't think we should just simply sit back and relax and wait until it reaches 10, 20, 30, 50, or 100. Again, without necessarily going back to the original provision, we can retain killing members of the group for as long as it is understood that if intent is clearly proven, that the intent is to commit genocide, kahit isa pa lang siguro, we can intervene and we should intervene and not simply sit out, relax and wait until it reaches a certain number. Again, without necessarily changing or proposing a change in the definition. Because the reverse is also true. Kung ang takot ni Manong Roy is baka may pinatay lang na isa, sabihin na genocide. Ang takot ko naman yung kabaliktaran. Baka kailangan natin maghintay na marami munang patayan. Kung maliwanag naman na genocide talaga yung intention.
May comment, Mr. Chairman. Mr. Chairman, the concern of the gentleman in the Senate panel is taken care of in the definition in the title, genocide. The purpose of this act, genocide means any of the following acts with intent to destroy. In other words, it is already established that there must be an intent to destroy it in big numbers.
In whole or in part.
In whole or in part. So it's there already. But if it's an isolated incident, in fairness to the military commanders who are going to be exposed to this law once enacted, it would be very unfair if there's one isolated incident. You know, a soldier can go berserk, killing a civilian who is a part of a national, ethnical, racial, religious group, and then that command will be accused of genocide, citing the IHL as the basis for accusing him of genocide, or even filing a case of genocide against the commander.
Again, without necessarily proposing that we revert back to the original Senate version, as long as that understanding and intent is clear, Mr. Chairman, Your Honor, I will interpose no objection as long as it is understood.
Thank you very much, Mr. Chairman. Thank you.
Well, after having taken a look at the definition, we're retaining the definition of the Senate. Genocide is here with as follows. For the purpose of this act, genocide means any of the following acts committed with intent to destroy, in whole or in part, a national, ethnic, racial, religious group such as. I would support now the definition.
Yeah, thank you very much.
Thank you. Insofar as pharmacologically, the position on pharmacological, what is your position again, Senator Golez?
I'm just concerned that removing it might diminish the meaning of torture, because we all know from history, from experience, that torture can be inflicted by use of drugs.
Yes.
And pharmacology is defined as follows. I lifted this from my own dictionary. Branch of medicine concerned with the uses, effects, and modes of action of drugs. In other words, if we remove pharmacological and presume that it's already subsumed under physical, then we might be minimizing pharmacology as a means of torture. I would like to propose, because there's no harm, even if it's already subsumed under torture, under physical torture, I think there will be no harm if we retain pharmacological.
With all due respect, and on a general note, I'd like to say I'd like to agree with the gentleman from the Congress, except that we really are focused on the effect rather than the means here. And besides, I'm told that on the Convention Against Torture, we're going to adopt Article 1, which means which defines torture as an act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes, in which case that would be covered. In the IHL law, the intent is to really go after the effect, not just the means upon which it is obtained. And so, consulting the members here from the Red Cross, International Red Cross, and they have a lot of experience here. Their position is it should not be included in the measure. Anyway, it's covered under the proposed provision of the law that my chairman is going to be coming in on torture, which adopts the convention also on torture.
Which JMA has not yet signed that?
Ano ba yan?
Tapos na, JMA has not signed that.
Hindi pa yata, well, the problem I think is in the House. We have not transmitted the signatures.
Well, I've always been in the position that it's not over until it is over. So we cannot say that just because there's already an anti-torture bill in the pipeline that we should already assume that it's going to be passed. But anyway, having heard that this is the position of the ICRC, I yield to their expertise, Mr. Chairman. Thank you very much.
Thank you. Just want to point out that I've gotten a lot of, this is not just my baby, it really is the baby of the international community here, and I don't mean to be the sponsor really. I mean, I was just the means to utilize this. And I think it's a very, very good law. Anything else?
Oh, yes. With regard to penalties, Mr. Chair, we did not actually put or indicate the fines to be imposed in the reconciled in the draft that we're looking at, page 14.
So is it your pleasure to put
yes,
yes, I quite agree with that.
Because if we can come out with a range, maybe for I would suggest, Mr. Chair,